Pvl2602. We're now dealing with some of the cases. Braun versus Blan. Braun, B-R-A-U-N, versus Blan, B-L-A-N-N, and Botha. Braun versus Blan and Botha. Conferment of a power of appointment upon a trustee. Conferment of a power of appointment upon a trustee. In clause 3 of her will, a testator had bequeathed the residue of her estate to her administrators. She had conferred upon the administrator inter alia the power to appoint in their discretion the income as well as the capital beneficiaries from a group of persons she designated. She further provided, when the trust must be dissolved, and in a provisor to clause 4d, she empowered her administrator in certain circumstances to apply such portion of the capital as they determine to the creation of a trust of such a lawful issue. Repeat, she further provided, when the trust must be dissolved, and in provisor to clause 4d, she empowered her administrator in certain circumstances to apply such portion of the capital as they determine to the creation of a trust for such lawful issue. The testator's daughter contested the validity of the trust on the ground that a power of appointment could not be confirmed onto a trustee. The court dismissed the application and the appeal was unsuccessful. Two important matters have been decided here. The first one concerns the granting of a power of appointment to trustees. After this case, it is certain that power can be granted to trustees to appoint beneficiaries from a specified class of persons designated by the testator. The second important matter decided by the appellate division is that the trust, mortis causa, is no longer constituted as a fideicommissium as previously. Repeat, Braun versus Blan and Botha. Braun versus Blan and Botha. It was the conferment of a power of appointment upon a trustee. In clause 3 of her will, a testator had bequeathed the residue of her estate to her administrators. She had conferred upon the administrator inter alia the power to appoint in their discretion the income as well as the capital beneficiaries from a group of persons she designated. She further provided, when the trust must be dissolved and in provisor to clause 4d, she empowered her administrator in certain circumstances to apply such portion of the capital as they determine to the creation of a trust for such lawful issue. The testator's daughter contested the validity of the trust on the ground that a power of appointment could not be conferred onto a trustee. Repeat. The testator's daughter contested the validity of the trust on the grounds that a power of appointment could not be conferred onto a trustee. The court dismissed the application, and the appeal was unsuccessful. Two important matters have been decided here. The first one concerns the granting of a power of appointment to trustees. The granting of the power of appointment to trustees. After this case, it is certain that power can be granted to trustees to appoint beneficiaries from a specified class of persons designated by the testator. Repeat. After this case, it is certain that power can be granted to trustees to appoint beneficiaries from a specified class of persons designated by the testator. Duplessis versus Strauss. Duplessis versus Strauss. The si sine liberis desirit clause. The si sine liberis desirit clause. The testator, one Strauss, in his will left the farm to his son, A. L. Strauss, and also bequeathed the farm to each of his two daughters. Their bequests were inter alia to a condition. If it leaves a benefit to A and provides that the property must go to B if A should die without children, si sine liberis desirit, there is no problem if A should die without children. Repeat. If it leaves a benefit to A, if the testator leaves a benefit to A and provides that the property must go to B if A should die without children, the si sine liberis desirit, there is no problem if A should die without children. B will then inherit the property. If A dies and is survived by children, the fiduciary commissary condition is not fulfilled and B can therefore not inherit. From this decision, it is clear that if a si sine liberis desirit clause is attached to a conditional fideicommussum, the mere fact that the children are not mentioned in the condition means that a fideicommussum tacitum is created in their favor, provided that the children are descendants of the testator. Repeat. From this decision, it is clear that if a si sine liberis desirit clause is attached to a conditional fideicommussum, is created in their favor, provided that the children are descendants of the testator. Next case, Gaffin, Gafin, versus Cavin, Kavin. Gaffin versus Cavin. The capacity of an heir to inherit from the wife whom he had killed while mentally ill. Repeat. The capacity of an heir to inherit from his wife whom he had killed while mentally ill. This is Gaffin versus Cavin. The respondent and his wife executed a joint will in terms of which it was provided that, in the event of his wife predeceasing him, he was to be the sole heir of her estate. The respondent shot and killed his wife and 2 of his children, and wounded his other child. He was charged with murder but found not guilty because he was mentally ill. He was incapable of acting in accordance with an appreciation of the wrongfulness of his acts at the time of the commission of the acts, and was accordingly not criminally responsible for his acts. The executor of the estate of his deceased wife applied for an order declaring that the respondent was unworthy to inherit from his wife's estate, in inverted commas, die bloedige hand. The court accepted the findings of the trial court that the respondent was not criminally responsible for his acts, and found that he was not disqualified from inheriting, from his wife. From this decision it is clear that where killing is justified, example, self-defense or no fault of the perpetrator, then he is not unworthy to inherit from his victim. Harris versus Assumed Administration Estate McGregor. Vesting on intestate succession. The testator created a trust in respect of the whole of his estate and stipulated that the trust income was to be paid to his wife during her lifetime. That the trust income must be paid to his wife during her lifetime. After her death, the trust capital was to devolve upon the children. Should they not have any children, it was to go to the brother, A.G. McGregor, and to his brother's children, if his brothers predeceased the testator's wife. Repeat. After her death, the trust capital was to devolve upon the children. Should they not have any children, it was to go to the brother, A.G. McGregor, and to his brother's children, if his brother predeceased the testator's wife. No children were born of the marriage of the testator, and his wife and his brother predeceased the testator's wife, the testator's wife leaving no issue surviving him. Every contingency that the testator provided for therefore failed, and consequently the capital of the estate had to devolve ad intestato. In this decision, the appellate division has brought about certainty concerning a matter on which the courts were divided in the past. Where the deceased died without making a will at all, or without leaving a valid will, the intestate estate vests on the date of his death, when his intestate heirs also have to be determined. On the other hand, where the testator leaves a valid will, which took effect of his death, but which subsequently became inoperative either toto or pro parte, the intestate estate vests on the date on which it became certain that the will had become inoperative. The intestate heirs will then need to be determined not at the testator's death, but rather when the intestacy occurred. Repeat. In this decision, the appellate division had brought about certainty concerning a matter on which the courts were divided in the past. Where the deceased died without making a will at all, or without leaving a valid will, the intestate estate vests on the date of his death, when his intestate heirs also have to be determined. So basically what that means is that if you die intestate and you don't have a will, or you die with an invalid will, the date of intestacy is the date of death. Where later on, if it is where a testator leaves a valid will, which later becomes inoperative, the date of intestacy is the date that it became inoperative. Jewish colonial trust versus estate Nathan, the meaning of the term vest. The testator bequeathed his estate in trust to administrators and directed that certain annuities were to be paid out of income for a period of 50 years. The testator. Next case is Kirsten versus Bailey. Kirsten versus Bailey. The testator made 3 wills shortly before her death. The defendant was only beneficiary in terms of the first and third will. The master accepted the third as the testator's valid will. The testator's intestate heirs, who were beneficiaries under a second will, challenged the validity of the first and third will on the ground that the testator had not had the required testamentary capacity when she made them. Repeat, the testator's intestate heirs, who were beneficiaries under the second will, challenged the validity of the first and third will on the ground that the testator had not had the required testamentary capacity when she had made them. The plaintiffs also claimed that the defendant had unduly influenced the testator when she made the first and third wills. The plaintiffs consequently claimed an order setting aside the third will and declaring the second will to be the testator's last will. Alternatively, they claimed an order declaring the testator had died intestate. The court held that she had died intestate. Lello versus Dales. Lello versus Dales. It's Lello versus Dales. The right of accrual, better known as ius accrescendi or crescendi. Ius accrescendi. The testator left her estate in trust and stipulated that the income of the trust was to be paid to a son Harry during his lifetime. On Harry's death, the estate was to devolve on his lawful issue. If he should die without leaving a lawful issue, the estate was to devolve as follows: half to my brother Edward, or his lawful issue, if any, and the other half in equal shares to my nephews and nieces and my children and brothers. In addition, Edward had 3 brothers. In all, these brothers had 13 children who survived the testator. Edward had never married and died intestate before Harry. Harry also survived the testator's remaining brothers. After he died childless, his widow, as executor, applied for a declaratory order to the effect that the half that Edward and his children would have inherited if they had survived Harry was now to devolve on Harry's estate in terms of intestate succession. The nephews and nieces opposed the application, contending that Edward's half accrued to their half of the estate. The court accrual held that Edward's half should go to Harry's estate. An appeal against this decision was upheld. Repeat. In addition, Edward had 3 brothers. In all, these brothers had 13 children who survived the testator. Edward had never married and died intestate before Harry. Harry also survived the testator's remaining brothers. After he died childless, his widow, as executor, applied for a declaratory order to the effect that half that Edward and his children would have inherited if they had survived Harry was now to devolve on Harry's estate in terms of the intestate succession. The nephews and nieces opposed the application, contending that Edward's half should accrue to their half of the estate. The court accrual held that Edward's half should go to Harry's estate. An appeal against this decision was upheld. Renz versus Esselin. Renz versus Esselin. In clause 1 of his first will, the testator bequeathed his farm to his son Douglas, the property situated at Margate to his son Stanley and daughter Stella. In clause 2ii, he bound the property by means of a fideicommisum in favour of their issue. At a later stage, the testator sold the Margate property and had to change his will as a result. In his second will, he bequeathed money to Stanley and Stella. At a later stage, the testator sold the Margate property and had to change his will as a result. In his second will, he bequeathed money to Stanley and Stella. The attorney who had drafted the second will and the testator's nurse testified the testator had instructed the attorney to delete clause 2ii of the first will, as he wanted to give Douglas the farms unencumbered. The will was typed. Clause 2ii was inserted by mistake as clause 3ii in the second will. The testator's sight was impaired, and as his eyes were tired, he did not read the will and just signed. Douglas applied for an order directing clause 3ii be regarded as pro non script. The court granted the application. This case's name is Renz, R-E-N-S, versus Esselin, E-S-S-E-L-E-N. Renz versus Esselin. In clause 1 of his first will, the testator bequeathed his farms to his son Douglas and property situated at Margate to his son Stanley and daughter Stella. In clause 2ii, he bound the property by means of a fideicommisum in favour of their issue. At a later stage, the testator sold the Margate property and had to change his will as a result. In his second will, he bequeathed money to Stanley and Stella. The attorney who drafted the second will and testator's nurse testified that the testator had instructed the attorney to delete clause 2ii of the first will, as he wanted Douglas to give Douglas the farms unencumbered. So the issue at stand here is rectification. That is Renz versus Esselin.